Go on the record. Good morning. Today is November 6, 2024. My name is Jennifer Grace. I'm the Public Utility Law Judge assigned to handle Public Service Commission case number 9732, which is a complaint by the Commission staff versus Yazam Incorporated doing business as Empower. If everyone can make sure your mics are turned on and kind of close to your face, they're pretty directional. We'll start with appearances from the company.
Oh, much brighter green light now. It's Matthew Madden from Kramer Levin, Naftalis, and Frankel on behalf of Yazam Incorporated doing business as Empower.
Thank you. Office of People's Counsel.
Good afternoon, Your Honor. Milan Tekla-Mikhail on behalf of the Maryland Office of People's Counsel. I'm also joined by my colleague, Nicole Zeichner.
Thank you. Staff.
Good morning, Your Honor. Kenneth Albert on behalf of staff, and I'm joined by the Deputy Director of the Staff Counsel Division, Peter Wolfson.
Thank you. I'm a little bit late taking the bench this morning. I just received it was filed at 12:52 under mail log number 313368, a motion to compel a response to OPC's data request to Empower. And then also received this morning was an email from staff
I brought copies, Your Honor, if you need.
So, have the parties received both staff's email and also the motion from Office of People's Counsel?
Empower received staff's email this morning, as Your Honor did. Staff just handed OPC just handed the motion to me probably minutes after you received it.
Okay. Staff, that email should be filed as a letter
Sure.
with the commission.
Yeah, I would note that we became aware of that decision, that Uber decision, on Sunday night. We wanted to be fair to the parties. We informed them on Monday afternoon when we realized we'd really have to bring it up to ensure a complete record in this case. We disclosed to the parties, and this morning I realized we needed to disclose it to you and candidly be transparent about how we planned, why we think is relevant evidence here.
All right. So staff will file that as a letter to the commission in the actual docket in this case, please.
Okay, I mean, you that exact email, or can I change the format of it? Should I file that email with just a cover note?
I think that would be best.
Good, thank you.
And I feel like I should object, just for the record, to what's effectively a SIR reply and submission as, I guess, supplemental authority of an 11-year-old decision just prior to the hearing, to which we haven't had an opportunity to respond.
Okay. So we originally had evidentiary hearings set up for this morning, and the parties had some issues with availability for the hearings Monday of this week and also today. We also have, so the hearing was changed to a motions hearing regarding staff's motion dated October 2nd, 2024, to require Empower to comply with discovery as per my decision at the August 13th, 2024 hearing, and to impose sanctions. And then we have a response from Empower on October the 4th, and then we have a reply. It's a response from staff to Empower's reply, I guess, dated October 9th. Now we have also the motion to compel responses to OPC data requests dated today, filed at 12:52. So we have a lot of things to talk about, but I did notice that in Empower's reply, Empower is asserting a lack of jurisdiction. Empower, did you Did you file a motion to dismiss for lack of jurisdiction?
No, Your Honor.
Okay. I'm going to take argument on jurisdiction in this matter, and that's what we're going to talk about first, and we'll see where it goes from there. So, go ahead, sir.
Okay, I think maybe there are two buckets of things that fall under jurisdiction. The entire proceeding here is to determine, the point of the entire proceeding here is to determine whether or not Empower is a transportation network company or TNC under the Maryland law and statutes. Staff's papers state quite clearly in their motion to compel that, motion for sanctions, that if Empower is not in fact a TNC, it has no authority to regulate it at all, and so it has no statutory regulatory jurisdiction over it. Empower, this is the short version, Empower doesn't employ drivers, it doesn't pay drivers. Drivers are Empower's customers, they subscribe to its booking platform. Drivers pay a subscription to Empower for its booking platform, but riders don't pay Empower for transportation services the way that riders pay Uber and riders pay Lyft. That makes Empower significantly different and means that the statutes that regulate TNCs that do provide transportation services don't apply to Empower. The purpose of this proceeding, as we understand it, is that staff takes a different view and believes that Empower is a TNC over which the Commission has jurisdiction. Again, Empower disagrees. And so in hopes of convincing Your Honor and maybe even the staff of our position on that, Empower has been participating both before this proceeding, all the way back to August of 2021, and during this proceeding to provide staff as much information as it can on that question. There have been, including subparts, over 150 different data requests on various aspects of Empower's operations, how it interacts with riders, how it interacts with drivers, et cetera, et cetera, et cetera, nearly all of which Empower has attempted and endeavored to answer over these many weeks, and there are still yet more pending data requests coming every day that we, again, endeavor to answer consistent with what's relevant and what's not overly burdensome. But sort of bucket one on Your Honor's jurisdictional question is just the basic question of this proceeding, which is whether Empower is a regulated entity subject to the Commission's authority or not. Separately, is I think the focus of the motion to compel is whether there's jurisdiction to compel Empower to respond to data requests as opposed to subpoenas or some other service of process. Staff hasn't cited any authority for compelling non-regulated entities to comply with data requests in a proceeding. It's going to cite and has provided Your Honor a copy of an Uber decision that involved a subpoena validly issued by the Commission under PUA 3-109A. That's not what we're talking about here. And so the ability to, for staff to compel an entity, the authority of the Commission over which hasn't been established yet to provide documents in connection with the proceeding over the jurisdiction in the first place, again, absent some subpoena or other service of process, is sort of a second jurisdictional issue that's at issue here today.
So, in Empower's response to staff's motion, Empower stated, Empower asserts a good faith jurisdictional objection. So I'm considering that to be a motion to dismiss for lack of jurisdiction by Empower. So I'm not interested in the short answer. I'm interested in the long answer. Okay?
Okay.
Why do you say Empower is not within the Commission's jurisdiction?
Sure. And just to be clear, we filed, I'm not entirely prepared to talk about that today, but I will. We filed a response to staff's complaint that lays this argument out in some detail, so I would refer Your Honor to that as well. But I will attempt the long version. The long version is that Empower is a software company.
Hold on a second. Are you
Yes.
talking about your October 4th response? Or are you talking about the original
The
response?
original response to the staff's complaint.
Okay.
Yep.
Go ahead.
Empower is a software company. It sells booking platform software to individuals who want to drive for themselves as drivers. Those individuals pay Empower a subscription fee for the use of that software, and that's their only relationship. Empower doesn't control the rides, it doesn't direct the rides, it doesn't even direct the subscribers to drive at all. Those drivers, in turn, use that software and many other services that they acquire to provide transportation services to riders on their own behalf. They set their own rates, they collect 100% of the riders' fares, and they otherwise control the provision of ride services entirely on their own behalf. The TNC regulations and laws in Maryland require that a transportation network company, as part of, and I don't have the, forgive me, I don't have the definition in front of me, but to be a transportation company, you need to have transportation network operators who are paying the TNC, excuse me, forgive me, the TNC needs to be paid for the provision of transportation services by the riders. That describes Uber, it describes Lyft, it may describe other companies that are regulated by the commission, but no rider in Maryland or anywhere else pays Empower to provide them a ride. Instead, they pay independent drivers who are working for themselves and want to set their own rate, set their own worth, and collect 100% of their fares. And those drivers then, in turn, they subscribe to Empower's booking platform and related services to enable them to do that. We use often the analogy to OpenTable. OpenTable is a booking platform software. It helps connect hungry diners with restaurants willing to sell them a meal. But that doesn't make OpenTable a restaurant. It doesn't subject OpenTable to the health department regulations over restaurants. Instead, it is just providing to restaurants a booking platform that they can use to sell more meals to diners who want to transact with them.
What is your relationship to the drivers?
There's a subscription agreement. So each driver enters into a subscription agreement. It's a software as a service agreement or a SaaS agreement, much like you sign when you buy a copy of Microsoft Word from Microsoft. It's an agreement that governs their use of the software and the fees and subscription fees they have to pay for its use. That's the only relationship between Empower and its customers.
Okay, Empower requires every single one of its subscribers to submit to a third-party background and driving history checks. Why does
Correct.
it do that?
To increase the value of the software so that it's more attractive to its customers and more people want to pay for it. So by being able to tell the world that all of its subscribers submit to a background check, which is just good business practice anyways, that makes it more attractive to riders who want to use it to find drivers who want to provide them a ride, and there in turn provides it more attractive to drivers who want to subscribe to a booking platform to do so. So it's to increase the value of the platform.
You just, in one part of your sentence, said to make it more palatable to, you didn't use the word palatable, but to make it more, I think you said
Attractive, I think. Yes.
to its customers. And then the second part you said to make it more attractive to its riders. Are those one and the same, its customers and its riders?
No. Empower's customers are drivers who pay them for a subscription of the software.
Okay.
So riders, maybe to answer what might the next question be, riders, in order to download the rider version of the software, they sign on to an acceptable use policy, which I'm sure you've seen and clicked through a million times like most of us, another sort of software-based agreement between end users and a company. Then in turn, riders, when they purchase a ride from a driver, they pay 100% of the fare to the driver through a third-party payment processor, Stripe. So Empower doesn't collect ride fares of any kind from the riders because those riders are purchasing transportation services directly from the driver. Again, unlike Uber and Lyft, who do sell transportation services to riders and are paid by those riders for those services.
Does Empower know whether or not the drivers and companies are licensed in Maryland?
Currently, Empower does not provide that check. Some of them no doubt are, because many of them also drive for other companies, even while they're driving on their own using Empower software. But it currently doesn't have a sort of a process to check for that. We have told the staff that we'd be happy to work with it to institute such a process. I think there's a roster online you can use to cross-check. We've offered to do that. If we could sort of all get in a room and talk about how to make that acceptable to staff, and they've declined to have that conversation with us.
How do you know that some of your drivers also drive for Uber or Lyft or some other company?
Anecdotally, we just know that to be true from just talking to some of the subscribers.
Empower does operate in Maryland, correct?
Yes, it provides software to people who are in Maryland, correct?
Okay. And do you know which of your drivers operate in Maryland?
I don't know the answer to that, the exact answer to that question, Your Honor. I apologize. We know some subscribers will provide address information when they subscribe, so certainly to the extent that we have that information, then we have that information. A subscriber doesn't necessarily have to remain in one jurisdiction, though, so I'm not sure. It sort of depends on the meaning of the word operate. I'm sorry to give a vague answer, but
So what specifically of 10101 doesn't apply to Empower?
that because riders don't pay Empower for software, for transportation services, they don't meet the definitions. The drivers who subscribe to Empower software don't meet the definition of a transportation network operator, and thus Empower doesn't meet the definition of a transportation network company.
Without the Empower software or platform or whatever you want to call it, how does one of those drivers connect to one of those passengers?
They could connect to passengers any number of other ways. They could drive for their friends. They could put a bulletin up in Starbucks. It is no doubt many of them think valuable and efficient for them to use, or also to use Empower's booking platform to find riders who want to use their business.
All right.
So for example, nothing keeps a driver who subscribes to Empower from having a relationship with someone who's ridden with them in the past, that they set up rides by text or any other way. There's nothing in the software agreement or anything else as between Empower and a customer that prohibits that or regulates it in any way.
So then what's the value of Empower?
Because
what are you selling?
we sell a software booking platform, much like OpenTable sells its platform to restaurants, that allow them to connect with people, allow subscribers who are drivers to connect with their prospective customers who are looking for rides.
All right. Do you have anything else to say on jurisdiction?
Nothing comes to mind, Your Honor.
Office of People's Counsel?
Yes, Your Honor.
Excuse me.
Empower's argument on this issue of whether or not they're under the Commission's jurisdiction is flawed for multiple reasons. One, they make the argument that the Maryland legislature, when it crafted PUA Section 10-101M2, which is the statute that governs TNOs, that it did not have an operation like the one that Empower is conducting in mind. But Empower does not point to any evidence that the legislature's intent when crafting the specific provision was for the payment exchange described within the provision to take place strictly within the passenger and the TNC in order for the driver to be considered a TNO. There is nothing in the legislature's intent that they could point to that there's a strict interpretation of how this payment exchange is to be made in order for entities other than Uber and Lyft to be under that umbrella. So they're asking for a jump in logic to be made in order for the Commission not to have jurisdiction over this matter. The legislature, when it acted Senate Bill A68, which is where we get the PUA Section 10-101M2 from, authorized the Commission jurisdictions over TNCs and TNOs and did not elaborate onto the sequence of payment obligations between passengers, TNCs, and TNOs, let alone set a strict requirement as to the payment exchange. Two, there's actually a payment exchange between Empower and the passengers, as Empower requires drivers to use a payment processing vendor of Empower's choosing, which is Stripe, to process passenger fees. Moreover, the amount that Empower charges drivers in monthly subscription fees is based partly on the number of rights that they provide, which is also why OPC in its motion to compel has questions in this arena, so we can find out how exactly does Empower determine its subscription fees, because if the subscription fees are impacted by the number of rides that drivers are conducting, obviously the amount of the payment that passengers are paying is impacting the subscription fee. So furthermore, Empower receives driver subscription fees from the same payment processing vendor that also processes passengers' payments, which means the fees passengers are paying are just getting relabeled as subscription fees in order to avoid a relationship between Empower and riders. Now, OPC also argues that the rules of statutory construction should be applied to PUA section 10-101L and M. Under the rules of statutory construction, the plain meaning of the language used in the statute is the principal step in determining the application of a statute. Evaluating the plain language of the statute requires that it be read as a whole and should not be read in a way that ignores common sense or logic. In this instance, the plain language under PUA section 10-101M2, which I'm trying to pull up to see the specifics.
M2 reads, receives through a transportation network company's digital network application a connection to a potential passenger to transport the passenger between points chosen by the passenger in exchange for the payment of a fee to the transportation network company and.
Thank you so much. It does not provide this subsection does not provide the necessary language to support Empower's interpretation under the aforementioned provision of the exchange of payment, meaning that it must take place between a passenger and the TNC for the driver to be considered the TNO. The provision could similarly be read as having the payment be exchanged between a TNO and a TNC. Moreover, the provision should be read together with the above subsection of 10-101L1, and when applying the definition of a TNC as stated under the subsection, it is clear that Empower meets the plain meaning of the definition. Empower is a company that currently operates in Maryland. It does use a digital network, which in this case is the Empower application. It connects passengers to TNOs for transportation network services as defined under section 10-101N1. And so when reading all these provisions together, it should not be read in a way that ignores common sense, which we believe Empower is asking the Commission to do in its interpretation of M2. And finally, I apologize, Your Honor, just give me a second.
No worries. Again, I want the long answer, so take
okay,
your time.
Great. This is going to be long. Furthermore, the Commission in case number 9325 rejected Uber's assertion, which is similar to that which is being made by Empower, that it does not meet the statutory definition of a common carrier because it is only a technology company and does not receive payments from riders. That was Uber's exact argument prior to the Maryland legislation enacting Senate Bill 868. And the Commission in that case rejected Uber's argument on the grounds that Uber exercises significant influence over and has the requisite control and management of the operation of motor vehicles engaged in transportation for hire. And we believe that similar interpretation should be applied in this case. The Commission based its finding of Uber's control of the transportation for hire services rendered by its drivers on the following fact. Uber could terminate its agreement with a driver and kick them off the platform. It provides customer services directly to passengers if they have an issue with their fare. Uber uses a third-party payment processor, and the terms and conditions of the driver and user agreements are unilaterally set by Uber. Just like Uber, Empower exercises considerable control over its drivers' operations. The software agreement that Mr. Madden referenced earlier, that drivers must sign in order to use the Empower application, is unilaterally drafted by Empower. There is a provision within the software agreement that allows Empower to terminate a driver's access to the application. Empower provides customer services to passengers directly. It offers promotional discounts to passengers. It charges cancellation fees to passengers without input from drivers, and extra. So if Empower was really operating as a software company that is just offering a platform for entrepreneurs, it would not have any impact on how the drivers conduct their business. So going back to the example that Mr. Madden used, if I book a restaurant through Open Table and I have a bad experience at the restaurant and I want a refund, I have to go directly to the restaurant to request the refund. I cannot get that refund through Open Table. But in the current apparatus that Empower has, if I am not satisfied with the services that a driver provides, and let's say I book that transportation service through Empower, I could go directly to Empower and request for a refund. And I will end it there as far as, in that regard, OPC believes that Empower is under the Commission's jurisdiction. Thank you, Your Honor.
Thank you, Your Honor. Start with the issue of Empower's duty to comply with your directive. We had, of course, the staff filed a motion to compel. Oh, just jurisdiction. I'm sorry. Okay. It's a bit of a time warp here because, as noted, that control standard, very de facto, fact-specific standard that was used in Uber, was essentially replaced and supplanted by what is a much simpler standard in the Public Utilities article. In 10.101, as was noted, if you go to the definition of a transportation network company, a TNC, 10.101L, as in Larry, it's a company, quote, means a company that operates in the state using a digital network to connect passengers to transportation network operators or transportation network partners for transportation network services. So it's undisputed that this is a digital network. It's a computer app, and the driver relies on that app to get connected with a passenger, and the passenger, by the same token, is connected to the driver. So it clearly fits under that definition. So when we go down this road of talking about control, while we think it may be relevant, it's significant that the statute sort of supplanted a very fact-intensive standard with one that is much simpler. Now let's turn to what Empower focuses on. Its connection with the definition of a transportation network operator in 10.101M as in Mary. And they focus, they say it's a TNO, quote, receives through a transportation network company's digital network application a connection to a potential passenger to transport the passenger between points chosen by the passenger in exchange for the payment of a fee to the transportation network company. Now, Empower says that we should insert in there where it says in exchange for the payment of a fee to the transportation network company, it should say in exchange for the payment of a fee by the passenger to the transportation network company. But it doesn't say that. It says a fee. It simply says there's a fee being paid to the transportation network company. It does not say who pays that fee. Now here, Empower concedes, as they must, that they make their money by charging a fee to the driver. And that fits clearly within the definition. And imputing additional language into a jurisdictional provision to restrict the scope of it would require some fairly compelling evidence that that was the legislative intent. And we don't see that. And OPC makes a very fair point that the compensation that a driver gets is related, their bonus is related to the amount of revenue that's being brought in. So there is sort of an element of, it's not just the fee, there's additional compensation going on. But again, I think we get ourselves in trouble when we depart from a very clean statute that took a very fact-specific standard and essentially threw it away and said, let's make this real, objective, and simple. So while control is interesting to talk about, and it's certainly relevant in the Uber decision, that was supplanted by the statute. Yeah, given where we are now, staff not having anticipated we would talk about jurisdiction, it seems that if we're going there right now, which is, I mean, that's obviously a threshold question, we would think a motion to dismiss would be appropriate. If Your Honor, dismissal of this proceeding, dismissal of dismissal of their. I'm sorry, I'm reading something from a script. Anyway, clearly that's where Empower is going, a motion to dismiss this case. And we're not getting into the issue of whether they're subject to the directives, and hopefully we can get into that later. But in terms of the jurisdictional issue, yes, we agree with you that we would have to dismiss this case if you determine that there is no jurisdiction over this entity. But that's basically why we're here.
Thank you. Go ahead.
Your Honor, may I briefly add something?
Yes.
A motion to dismiss, which is essentially what Empower is attempting to do, should have been filed much earlier in this proceeding. We recognize that the court does not have to abide by the Commission does not have to abide by the Maryland Rules of Civil Procedure. But it's worth noting that the Maryland Rules of Civil Procedure, specifically Maryland Rule 2-322A, requires the defense of lack of jurisdiction over the person to be filed prior to the filing of an answer. Here, Empower has not only filed an answer in which it at no time stated that or requested that this matter be dismissed, but it has also availed itself of the benefits of the Commission's procedural schedule by filing testimony and participating in discovery up until this point. It would seem unfair, might be an understatement, but at the very least it would be unfair for this far into the proceeding for Empower to attempt to have this matter dismissed. That would be a threshold question that OPC respectfully suggests should have been filed at the beginning.
Thank you.
Your responses,
Sure.
if I may. Just first on the motion to dismiss, I find that somewhat perplexing. All of the I apologize. I started by saying, if I just may have a few minutes. To start with the motion to dismiss suggestion, I find that perplexing. All of the parties have treated this proceeding from the start, from what staff asked for in its complaint, to be about whether Empower is or is not a TNC. And that's what we've been doing for the last 6 months, is engaging in discovery on that question, giving them information that they purport to need to answer that question. The idea that we would have, or even could have, moved to dismiss this proceeding before all of that happened is not only perplexing to me, but it's contrary to the conduct of the parties over the last 6 months. And if I knew this was an argument they would be making today, I could provide you the emails and the letters that make very clear that we all knew what we were doing for the last few months and the inquiry we've all been engaged on about that question. First, so as I said at the outset, Empower is trying to provide a software service that individual drivers can use to work for themselves and sell their own transportation services at rates they set and fares they collect and keep 100% of. Staff and evidently OPC's reading of the statutes would require every driver in Maryland to work for a big transportation network company. We think that's not only not what the statutes require, but also bad for Maryland drivers and consumers, who are better off from having Empower operating in Maryland because its drivers are providing rides at lower average rates, and they're doing so at fares that they can keep all of rather than having to give some to some big company that they have to work for. As for how the statute allows that, we've focused on the right statute. I finally managed to pull it up, and Your Honor read it. A transportation network operator, which is required for there to be a transportation network company, is one who provides a connection. A connection to what? A connection to a potential passenger to transport that passenger between points chosen by the passenger in exchange for the payment of a fee to the transportation network company. Of course, it's the passenger paying the fee, making the payment of a fee to the transportation network company. Passenger is a noun immediately before, in exchange for, and it's also what the legislature was used to and focused on when they passed the statute in the first place, because as I've said, when you order an Uber or you order a Lyft, you do pay your fee, your entire fare, to the transportation network company. That's how it's set up, and that's what the legislature had in mind. That's why they wrote the statute this way. If you take the opposite view of the statute, then I suppose Empower is a TNC, but Uber and Lyft are not, which can't possibly be what the legislature intended. There were a number of factual assertions made about control over the drivers, refunds. I could tick through those, but they are all evidentiary questions on which you might imagine Empower and it has a different view. So just for example, Empower, as one of the services it provides to its customers through the subscription agreement, provides for a sort of complaint and refund service that the customers pay Empower for as sort of a insurance so they don't have to be the point of contact on those kinds of disputes. I could go through other ideas that were raised as well about things that Empower offers as part of its services to the customers, but the main point is that Empower doesn't enter into a contract with a rider to provide them transportation services and doesn't connect a dime from the rider.
Your Honor.
In addition, just a minute. In addition to, so I think you just responded to OPC's argument that Empower offers refunds to riders. Does Empower offer refunds straight to riders?
I'm just not remembering the full answer to your question, Your Honor, at the moment. I believe that as part of the services that its customers contract for, Empower can provide refunds on their behalf. I'm just not remembering, as I sit here today, whether the money is then taken from the driver or something else. I apologize.
Okay, you don't know whether the money is taken from the driver or whether it comes from the subscription service that the driver pays for, but do you
Correct.
give the money to the rider?
I apologize. I don't know the answer to that question. We could follow up, but I don't know the answer to that question as I sit here right now.
Okay. Cancellation fees, same question. Do you provide cancellation fees?
Yes, that's in the that I know is in the software as a service agreement, which I believe is in the record. So the customers, the drivers, agree to certain cancellation policies in the software as a service agreement so that it's standardized across the platform and there are no surprises.
Okay, and then what is the relationship between Empower and the riders regarding cancellation fees?
The riders pay the drivers.
Okay, the subscription fees,
Yes.
how do those work?
It's changed over time, but currently there are a number of different models. There are flat fee models, and then there are models that some customers choose that are based on the volume of their rides in sort of broad categories, with the idea being that we want to sort of price the platform for the amount that people are using it, but it's not on a per ride basis. It's on a sort of an overall volume basis.
So is that there are different overall volumes per month?
Correct, exactly.
And what are those?
I would need a minute to find them. I can, it'll just take me a minute.
Okay, I'll wait.
Thank you. Okay, I found it. And Your Honor, much of this information is on Empower's website in FAQ sections for prospective and current drivers, but so that's what I'm reading from if Your Honor wants to look for reference. But in the Washington, D.C. metro area, there
Does that
are...
include Maryland?
Yes, it does.
Okay.
Yes. There are 3 subscription options currently. One is called Empowered DC Monthly Flex. And in that model, the subscription fee increases as the driver's earnings increase, as the drivers collect 100% of their fare. So as that number changes, the subscription fee goes up. So again, this is online, but it is. I'm going to round up the penny. It's $49.99, but call it $50 for earnings up to $250, $100 for earnings up to $500, $150 for earnings up to $900, $200 for earnings up to $1,400, $250 for earnings up to $2,000, $300 for earnings up to $2,500, $350 for earnings up to $3,000, $400 for earnings up to $3,500, and then $450 for unlimited earnings. That's subscription plan number 1. Subscription plan number 2 is called Empowered DC Monthly Platinum. This is priced at $350. Sorry, I'm just making sure I didn't forget a detail. Yes. Empowered DC Monthly Platform is a $350 flat monthly fee. And then there is a subscription third called Empowered DC Daily, in which customers who infrequently use the software sort of on and off as a sort of a part-time job, that is priced at $25 a day, again, rounding up a penny.
Okay, thank you. Are empowered drivers, would you say they're under the commission's jurisdiction?
So
That operate in Maryland, obviously.
a driver who provides transportation services may well be subject to the commission's jurisdiction, correct?
In what cases would they not be?
I don't know the extent to which there are sort of limitations on how often they need to operate or things like that, but certainly I can't think of any cases in which they wouldn't be, but it depends on the services they're providing, I suppose, and how often they provide them.
You said earlier that you were able to pull up the statute.
Yes, Your Honor.
101.
Yeah, yes, I have it.
Looking at section N,
Yes,
where it talks about period 1, period 2, and period 3.
correct.
Empowered does not disagree that its services fall under those categories, does it? I don't believe so. I haven't tracked all of the, but it offers a booking platform for rides that may qualify as transportation network services. And so my hesitation with Your Honor's question before, and maybe it was too technical, was you use the term empowered drivers. We don't think there's such a thing as an empowered driver because they don't work for us in any way, and they don't always have to drive for Empower either. So they could be performing services when they're not logged in. But helpfully your question directs me to this, which means if they're logged into a booking platform that qualifies under N1, then yes, a driver who's doing so would be subject, I believe, to the Commission's regulation. And we've been offering to work with the Commission to facilitate that regulation directly of drivers who are driving for themselves and providing transportation services in Maryland. And empowered does fall within those descriptions under N1, correct? The empowered platform.
Sorry, again, maybe I'm being a little too technical, but
I'll ask it a different
okay.
way. Does the Empower platform allow the operator to log onto and be ready to accept a prearranged ride request made through the digital network?
I'm not sure, and here's why. When you buy a ride from Uber, you've bought a ride from Uber, and it is prearranged with Uber, and then it lets its drivers accept or reject those rides. I'm not sure if a ride booked directly because you don't make the contract with Empower, I'm not sure if it's prearranged, but generally speaking, we agree that a rider, I keep doing this wrong, a driver who is logged into a booking platform and using that to arrange rides should be subject to Commission regulation, and we're eager to work with the Commission to make that work. Whether these particular statutes from 10 years ago used the right words for the Empower's model. I'm less sure, but Empower completely agrees that riders who are driving for themselves should be subject to regulation.
I'll use the word subscriber, so I'm using your, verbiage.
Yes.
When a Empower subscriber wants to drive using the Empower app,
Yes.
does the driver first log in?
Yes.
Okay.
When it wants to arrange a ride through the Empower app, it logs in. Correct.
Okay. When it's ready to drive, correct? When it's ready to take a ride, they log in. They're not logged in all the time.
I would assume correct. I would assume not.
Okay. And they do that through the Empower platform, correct?
They log into the Empower platform when they're looking to arrange a ride via the platform.
Okay.
Yes.
And the platform allows for the passenger to request a ride, correct?
Correct.
Okay. And then the driver transports the passenger and the app is still on?
I would assume so, yes.
Okay. And you're not asserting that Empower falls in N2, which is the exceptions?
Oh, sorry.
Oh, there's a question mark at the end of that statement.
I think the answer is yes. To the extent that what Empower's platform provides are transportation network services, then the three exceptions under N2 do not apply to it.
Thank you. Office of People's Counsel, you had something further to say.
Yes, Your Honor. If you may allow me to recollect my thoughts.
Absolutely.
I believe it was on section PUA section 10-101L. Empower makes this argument that it could. Well, I apologize. Section 10-101M2, where we're discussing fee exchanges. Empower asserts that it could only be interpreted as a way of the fee exchange occurring between the passenger and the TNC, and if it's interpreted in any other way, then it excludes the operations of Uber and Lyft. But the interpretation does not have to be mutually exclusive. There's nothing in the legislature's intent in crafting of SB 868 or anything that Empower has pointed to that says there has to be this strict construction or interpretation of this statute. It doesn't have to be an either or. It could be both. You can interpret it both ways in order to get to the intent of the legislature, which was to make sure that operations that like Uber and Lyft and Empower are under the commission's jurisdiction, and that there's a public safety aspect that is being protected by having them under the umbrella of the commission. So I just wanted to point out that it doesn't have to be an either or interpretation. It could be both.
All right, thank you. I see staff raising their hand.
Yeah, thank you, Your Honor. Not to belabor the point. Again, staff's concern is if we go with Empower's argument and we interpret 10-101, what are we at, M2, that payment of a fee to the transportation network company is only referring to a situation the passenger pays Empower. We're concerned that that will be jumped on. Uber and Lyft will jump on that, and we'll find ourselves in a situation in the state where there will be no regulated TNCs. In and of itself, that may not be significant, but what is significant is these are companies providing using thousands of drivers with thousands of vehicles providing transportation services. There's a huge public safety issue there, and we believe the legislature intended this to apply broadly, precisely to ensure that the commission's jurisdiction was broad. Because again, if we say it's just for payment of it only applies where the payment of a fee by the passenger to the TNC rather than the Empower model, where it's a payment to the driver itself, they will find clever ways, and they have it, I don't mean that in a negative way, but they can come up with other payment models that they could claim do not involve payment to the TNC, to the driver himself. So I think that we have to be careful if we choose to impose restrictions on the clear language of the statute. The practical impact of that may be undermine essentially the whole point of the TNC law. And if I might, just one other point, staff, Empower keeps on bringing up the fact that when staff expressed our concern, which we still have, of course, that we don't know who these drivers are. We can't vet them through see if they're approved for hire drivers, TNOs, Transportation Network Operators. They asked us for a copy. They said, staff, please send us a copy of the list of authorized drivers, authorized for-hire drivers in Maryland, and we'll go through the list for you. We can't do that. I mean, there's confidentiality at stake. We are not allowed to disclose that list of authorized drivers. And candidly, there's obviously a little conflict of interest there. I mean, part of the reason the commission does these functions in terms of vetting drivers is to ensure that's being done by a neutral, objective entity. But again, we're barred by law by sharing that. We weren't, Empower suggests that we're somehow standing in the way of what they're trying to do. And final point, they do make the point, a fair point, that they're saying, look, Empower, we're giving drivers a better option, better payment, better compensation, better service. They have more control of their services. Let's be clear, staff is totally for that. That's the whole point of competition. And that's part of the policy in Maryland on telecommunications, on gas and electricity suppliers, is to encourage competition because we think everyone benefits from it. So we have no problem at all with Empower's claim that they're providing a better deal for drivers, so why is staff trying to drive them out of business? Our point is we encourage that, but it has to be within the confines of a regulatory scheme that, again, has a compelling public policy objective of protecting public safety. So we, again, get back where we started. We have thousands of drivers for Empower. They won't tell us who they are or the number of them, using thousands of vehicles. They won't give us information about those too, so we don't know if those have been vetted for the annual inspection and other requirements. And this is a huge public safety issue. That's all I have.
Anything else from Empower?
I would only, just on that last comment, say, as I think council knows, we have been trying to work with staff for months because Empower doesn't believe this should be unregulated. It should be regulated, but it shouldn't be regulated by treating Empower as something it's not, which is a TNC that sells transportation services in exchange for fees. And when you have an entire statutory and regulatory scheme that's built up around that idea, it doesn't work just to sort of put a square peg in a round hole and say, well, context and statutory hopes and dreams make it so. We want there to be, Empower wants there to be a way to regulate drivers who work for themselves using a platform like this. But under staff's interpretation of the laws, that's not possible. It is not possible, as they see it, for a driver in Maryland to drive for themselves, set their own rates, and collect 100% of their fares using software like Empower's.
I was going to give Empower the last word, but I see OBC looking for another word, so go ahead.
You would ask about refunds, and I have located language regarding refunds in Empower's software as a service agreement, which they reference in answer to data request 1.1 to OPC. Empower states the only contract between Empower and drivers that use Empower's software is the software as a service agreement. And it is online, and I could provide the reference to Your Honor. It's https://driveempower.com/SAAS/. And I could direct Your Honor, I will read the language. It's section 4.4, consumer payments, under subsection IV, and it states refunds. Customer authorizes Empower to refund payments to consumers or third parties on customers' behalf if Empower determines that the consumer services to which such payments relate were not provided in full, the customer violated the terms of this agreement in connection with such consumer services, or such payment was otherwise associated with fraudulent or apparently fraudulent behavior of the customer or such consumers or third parties. And then in all caps, in such event, customer authorizes Empower to transfer the amount of any such refunds from customer's Stripe account to such consumers or third parties. If customer's Stripe account lacks sufficient funds to transfer payment in full, Empower may take the same actions described in section 4.1 III above. So there is reference in this agreement to how customer or consumer, essentially passenger refunds are processed.
Does that refresh
That
your
sounds,
recollection?
that does, thank you. That sounds right to me. So again, as I think I said was my understanding, at least first and foremost, the refunds come from the driver to the rider. There is, now recall, as part of the software as a service agreement, Empower provides a backstop in the event that, basically, again, to build value of the platform, that if a if a driver doesn't have funds available to make the refund, Empower provides the refund.
And also, Empower takes the funds from the driver's account initially and gives it to the rider.
No, I believe the refunds are directly from the driver to the rider. So it's from the driver's Stripe account to the rider. Apologize, I'm trying to pull it up. I don't have the internet connection that everyone else in the room has, but I'm doing my best.
Counsel, can you approach?
Sure.
I'm providing counsel with the password for the Wi-Fi in this room. I have pulled it up. I can read the relevant portion if that would be faster.
Thank you. I'm sure it would be.
Okay. Customer authorizes Empower to refund payments to consumers or third parties on customer's behalf if Empower determines basically that there's cause, yada, yada, yada. In bold, in such event, customer authorizes Empower to transfer the amount of any such refunds from customer's Stripe account to such consumers or third parties.
Correct. I believe that's consistent with what I said. So the refund.
Customer authorizes Empower to take the money from the customer's account and give it to the rider.
Correct.
All right. Any other arguments on jurisdiction?
Well, just a real quick one. Empower has brought up this idea that staff's being stubborn. They want to, and they have. That is, Empower has repeatedly said to staff, "We'd like to sit down and chat with you about ways we Empower would be a non-jurisdictional entity, but we would work out with staff conditions, service conditions that staff would be comfortable with to provide public protections." And we have said, and we've said in our pleadings, we don't have that. Staff does not have the authorization to negotiate with an entity that we have yet to determine is a jurisdictional entity. Our jurisdiction is mandatory. And if you're jurisdictional, all our rules apply. Of course, you can come in for waivers or exceptions. For example, TNCs have received waivers of the requirement to get fingerprints from their drivers. But we can't, if you're within our jurisdiction, we can't kind of have an alternative form of jurisdiction. And again, we get back to the fact Uber and Lyft are out there. If we start allowing entities like Empower to come in under the radar and non-jurisdictional, will negotiate conditions with you, rest assured Uber and Lyft will be coming in and say, we want that same sort of deal. So we just want to make clear, staff is not trying to get in the way, and we welcome competition for sure, but we don't have the authorization to negotiate alternative regulation with a TNC that asserts that they believe it's best for them to have that.
Last
Yeah,
cha-
that's
wait,
just
a second.
of
Last
course.
chance, Office of People's Counsel. I'm going to give you the last word.
Thank you so much, Your Honor. I just wanted to add the point that if Your Honor have found our points on jurisdiction to be insufficient today, it's because we have not been able to garner the information that we need in order to analyze these points from Empower. They have been giving us a lot of pushback about information that we need in order to assess if indeed they are or are not a TNC. And therefore, we urge Your Honor to grant us this motion to compel, and also staff's motion to compel, so that we could have further information to assess whether or not Empower is a TNC and whether or not their drivers are TNOs. And all of the questions that we have asked through our data requests, I know Empower thinks they are a large amount, but they're really questions to get at the heart of whether or not they're a TNC. They claim they're not. Well, just provide us the information we need in order to assess that fact. So I just wanted to add, if you do find our arguments to be insufficient, then please grant us the motion to compel so that we could gather that information. Thank you.
Well, I want to address the motion to compel. I haven't read yet, but Empower has responded to, as I said, more than 150 data requests in this proceeding. I think some of the pushback are sort of endless follow-ups of, we've read your answer, but can you say it a different way? And at some point, enough is enough. But we are doing our best to respond to both staff's and OPC's requests, which have been voluminous and keep coming even as recently as, I think, last week. The point I wanted to make about staff's point about discussions is I think it's just inaccurate. And the history of Uber and Lyft in this jurisdiction proves it. When Uber and Lyft came to town, the statutes and the regulations didn't quite suit them either, and they kept operating, and staff kept talking with them. There were settlement agreements. There were efforts made to revise statutes and regulations as necessary so that Maryland consumers could have an option. Empower is new and it is different. It is not structured like Uber and Lyft. It is trying to do something different to, if I may, empower drivers who want to work for themselves and don't want to work for a big company, and who want to own their own business, set their own rates, collect their own fares for their own customers. We have been trying since staff first reached out to Empower back in the summer of 2021 to have these conversations, to provide information, to work on a way that empowers customers can continue to earn a livelihood in Maryland by running their own businesses and providing transportation services directly. The idea that staff can't sit down with us and have that conversation until they win is simply not true. There's no authority for that in the statute, and it's not consistent with what happened when Uber and Lyft came to town. Uber and Lyft are now the incumbents. I'm sure they would have something to say about staff meeting with Empower, but that's not what benefits Maryland consumers, who in increasing numbers are looking to Empower to Empower's customers to provide them their transportation services.
Your Honor, if I may,
Is Empower still refusing to answer staff DRs 2.8, 2.18, and 3.8, and OPC's, whichever one's OPC, it has an answer from OPC as a base because of its objection to the Commission's jurisdiction?
It objects to providing its customer lists on the basis of jurisdiction. It has made offers to staff on DR 3.8, which I believe is the one about revenue, that staff has rejected without any counteroffer. I think they just want all of Empower's financial
I'll be more
information.
specific.
Sure.
Is Empower still, on the basis of a lack of jurisdiction, refusing to provide staff in response to DR 3.8 all of its revenues in Maryland? Not just the ones from first half of this year, an estimate of the ones from the first half of this year.
I believe so. I'm hesitating because we've made offers to staff to do something in the alternative, and when we were last before Your Honor in August, there was discussion that there would be a meeting in which Empower would provide revenue information. Staff has declined to have that meeting, so we haven't ever gotten to the point where I've had a conversation with my client about jurisdiction over that request. But generally speaking, Empower's position is that the commission doesn't have jurisdiction over it because it is not a TNC. So I guess that's true of every request, but we have been nevertheless trying to work with staff and OPC to answer as many of their questions as we can.
Okay, thank you. I think I have enough information. I'm not going to issue a ruling from the bench. I'm going to issue a written ruling. So stay tuned for that fun piece of reading pleasure. I believe with that we're finished for today, and we can go off the record.
Thank you, Your Honor.
Just to be clear, there are no future, right now we're not setting any hearing dates, obviously pending what you'll be doing.
Correct.
Thank you.
Thank you.
Your Honor, I